Okay, student, welcome back to session business law. So, in this session, we can discuss about the discharge of contract and remedies for breach of contract. So, you can recognize or recall the word discharge remedies from the subject corporate social responsibility of third semester BBM or the second year PUC business economics or business studies. Okay, in this unit you can understand the basic concept and law of the business, and you can learn or you can able to understand this session what are the problem arise in the economic and how to solve the such problem. Okay, discharge and remedies for breach of a contract. When a promise or agreement is broken by any of the parties, does not keep their end of the agreement or does not fulfill their obligation as per the term of the contract, it is a breach of contract. The discharge of contract. There are so many types of discharge. You can learn one by one. So, first one, discharge by performance. When the parties do a contract, fulfill the obligation arising under the contract within the time and manner prescribed, then the contract is discharged by performance. Actual performance and attempted performance. Second one, discharge by mutual agreement. If all the parties to a contract mutually agree to replay the contract with a new one or annual or remit or altered it, then it leads to discharge of the original contract due to a mutual agreement. Then discharge by lapse of time. If the promisor failed to perform and the promisor failed to take an action within this specified period, then the latter cannot seek remedy through law. It discharges the contract due to lapse of time. Discharge by operation of law. A contract can be discharged by operation of law, which include the insolvency or death of a promisor. Discharge by the impossibility of performance. If it is impossible for any of the parties to do the contract to perform their obligation, then the impossibility of the performance lead to a discourage of contract or discharge of the contract. Discharge by the breach of contract. If a party to a contract fails to perform his obligation according to the time and place specified, then he is said to have committed a breach of contract. The remedies of the breach of contract. There are so many remedies of the breach of contract. You can study one by one. First one, money damages. Money damages refers to the monetary payments which a breach of party has to make for violating the terms of contract. The types of breach determine the extent of the damages. Then, restitutions. Restitutions is a remedy which is used to restore the injured party to the position occupied before the contract. Under the principle of restitution, the defendants is supposed to give back any money or property received from the plaintiff under the contract. Rescissions. The contractual duties of both the parties may be terminated by the court, and when the happiness, it is called rescission. This remedy is used to certain cases such as when the parties enter into a contract because of mistake, fraud, influence, or duress, or thus, and the only way to do justice is to terminate the contract. Reformation. Sometimes the remedy of reformation may be used, which is when court reform or changes a contract to correct any iniquities. In these cases, instead of setting aside the entire contract, the terms of the contract may be rewritten to do justice. Remedies of breach of contract. The breach the breaching party has to perform their duties as specified by the contract, and it is used when money damages are not adequate to compensate the plaintiff. Specific performance is used in the cases which is involved given the piece of land or valuable them to the plaintiff. Specific performance. So student, you can need further go through the Google website and given the address, and also study the BS Raman of Business Law and Dr. Alice Money of the Business. And also in this session given the multiple choice question, you can read and choose the correct answer. There are given which one of the following is not method of which contract can be discharged. Given 4 answer, select the correct answer. Dash is the action to undo a contract. Given the 4 answer, selected the correct answer. Dash is the court order that prohibit a person from doing a certain act. Given the 4 answer, select the correct answer. Generally, dash damages are not recoverable for breach of contract. Given the 4 answer, select the correct answer. Okay, thank you students.